Why do spouses want to benefit the other? Why do they conclude a prenup and agree on a surplus allocation, also known as survivorship clause? What does this have to do with bequesting? How does this affect the calculation of the compulsory portion? This is what this video is all about. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich. If you like this video, please forward it to someone else. Elderly couples often favor the other for old age provision. Young couples with offspring buying a house wish to benefit the other in the event of their death. For the surviving spouse, it is often decisive what he or she receives under marital property law. The divisions of marital property law apply to the division of matrimonial property. Without a prenuptial agreement, the spouses are in principle subject to the provisions on the community of accrued gains. The law provides for 1/2 participation in the surplus. This can be deviated from by agreeing on a different participation in the surplus by prenuptial or postmarital agreement. For example, upon dissolution of the matrimonial property regime by death, the sum of both surpluses may be allocated to the surviving spouse, so-called survivorship clause, or also known as total surplus allocation. Thus, only the testator's own personal property is handed down to somebody. Basically, Article 216 of the Swiss Civil Code tolerates a special right of inheritance. Only joint issue need to accept that. Thus, a distinction must be made as to whether the surviving spouses have joint or non-joint children. The participation in the surplus allocated above 1/2 shall not be added when calculating the compulsory portion of the surviving spouse or registered partner, the joint children and their descendants. However, such an agreement must not impair the rights to compulsory portion of the non-joint children and their descendants. In other words, the other half allocation of the surplus is subject to addition and thus must be considered in the case of non-joint children. Before January 1st, 2023, the qualification, the calculation of the compulsory portion and the order of abatement used to be disputed. Today, according to the new revised inheritance law, the gifts subject to addition under a prenuptial or property agreement are considered as inter vivos gifts, and they are the first to be reduced. I would like to point out that there is no remarriage clause provided for by law. The status of the surviving spouse is strengthened in the classic family model with joint children. This also means smaller compulsory portions for your joint issue. The testator's own property is included in the estate. Its value must be determined. This simplifies and accelerates the division of the estate. However, remarriage of the surviving spouse may have a very negative impact on the joint descendants. This must be countered with contractual protective clauses. This is because only in the ideal case may the joint descendants benefit from all the assets still available in the event of death of the surviving spouse, so-called second death. Pay also attention to pending divorce proceedings. After the means of the decedent during pending divorce proceedings, which result in the avoidance of the forced heirship of the surviving spouse, such benefits from prenuptial agreement shall cease by operation of law. In other words, the surviving spouse cannot derive anything in his or her favor unless the marriage contract expressly provides for this. Please make a note of whether a prenuptial agreement may make sense for you. If a prenuptial agreement should already exist, please note, what have you agreed on? I look forward to supporting you fulfilling your personal and last wishes to have a peaceful distribution of your assets. Please contact me for a consultation.